God save the United States and its armed court. This armed court is now in session. Please be seated and come forward.
Good morning, everybody. We have one case on this morning's calendar, and it is Lee R. Carper versus District of Columbia, number 23 CT 345. Whenever you're ready, Mr. Madsen.
Good morning, Your Honors, and may it please the court. Adrian Madsen on behalf of Appellant Lee Carper. I'd like to reserve 3 minutes for rebuttal. Your Honors, even before getting to the question of whether the government must disprove out-of-state licensure as an element of the offense of no permit, or whether out-of-state licensure instead is an affirmative defense, 2 errors prior to trial independently require reversal. The first is that the trial court abused its discretion by granting over objection a day of trial oral request for a continuance without a showing of any of the 4 of the 5 elements required under O'Connor and other cases of this court to obtain a continuance based on a missing witness. More specifically, the district failed to proffer, and there was no evidence regarding the identity of the witness, the expected testimony of the witness, the relevance and competence of that testimony, and whether the district had exercised diligence in trying to secure the witness's presence. By failing to consider, let alone find, any of those 4 required elements, the trial court abused its discretion in granting the continuance.
Can I ask you a question? I mean, we can talk more about the merits of that issue, but if you're right on this, what is the remedy that you're seeking?
So the remedy I am seeking is reversal of his conviction. That is, without the prejudice that flowed from this obviously was the testimony of the officer. I agree the district could retry the case. It's not an issue of sufficiency, but that is the remedy that I am seeking.
But that seems like an odd remedy, right? To say, well, because the trial was held, how many days after was it? 12?
12 by my
12
count, yes, sir.
12 days late in your estimation, you get a new trial several years after.
So, Your Honor, I agree that it is a interesting feature of the trial court's discretion regarding whether to grant a continuance, but I was pondering this in preparation for argument. It seems that otherwise, in many ways, it would be creating a right without a remedy, right? That is, if the answer is, well, there ended up being a trial at whatever point it was later, no matter the trial court's errors, I'm not sure of what another remedy would be.
Well, another possible remedy, it seems like, in theory, whether it would be an appropriate one, I'm not expressing any view, but at least in theory, a remedy could be a limitation, a new trial at which the evidence that would not have been available if the trial had been held when it should have been would not be permitted. That's if you think the prejudice was the prosecution would have had to go to trial without witness X, then you could say, well, let's try to reconstruct the old trial as best we can rather than having a new one 2 years later. That's a theoretical remedy. I haven't understood you to have asked for it or to briefed whether that would be an appropriate remedy, but at least in theory, there might be other remedies.
Fair enough, Your Honor. I take Your Honor's point, and I again haven't briefed that, but don't think that would be an inappropriate remedy. That is, it would be a way of not having a right without a remedy that doesn't require having the new trial, as Judge Easterly just asked about, several years after the fact for a difference of, in this case, 12 days.
But just to be clear, the day of trial, you were pushing back on the request for continuance, and what would have happened if you had won that argument is they would have had to go forward with the trial. I mean, who knows, maybe the witness would have finished his grand jury duty and hustled over, but basically they would have had to go to trial without that witness, and presumably they couldn't do that.
Yes, Your Honor. And so I think what would happen on remand if we were adopting the remedy that Judge Cleese posited, if we were reconstructing this, that in the end we would have an acquittal.
Well, I didn't see that it was clear in the record that the witness at issue was in fact Officer Rosa. That seemed maybe inferential, but was there some place where it's explicit that witness was Officer Rosa, or is that your inference?
Your Honor, it is not explicit. I agree, and that's part of the argument, regarding that is that they did not identify the witness. I will say they've referred to the officer in the singular, and that there was when and again, understanding this is 12 days later, when the second trial happened, or the first trial and the second date happens, the only other witness the district calls is the DMV custodian or the DMV technician.
I tend to agree it's a reasonable inference. I was just curious whether I'd missed some place where it was explicit or whether that's an
No,
inference.
it was not.
I mean, it just seems like maybe you would want to say that there would need to be some fact finding on remand as to who that person was, because if you concede that it's obvious that it's Officer Rosa, then it seems to undercut your argument that the court didn't adequately consider 4 of the factors. I think you're down to 3 then.
Yeah, Your Honor, my point in saying that there would be an acquittal is not necessarily that it would be Officer Rosa, but that where the district referred to the officer in the singular and where there was no other means by which evidence that Mr. Carper operated a motor vehicle would have come in. It doesn't, in that respect, as to whether or not the district would be able to carry its burden, it doesn't really matter who the identity of the officer is for that purpose. And so I'm saying, is that an inference that could be drawn? Sure, it could be. It's an inference that could be drawn, but there was not evidence before the trial court at the time that would have allowed it to draw that inference. That is, sitting here today, we certainly could draw that inference, but there was not evidence before the trial court that would have made that clear.
But putting the point more abstractly, if again, this is a remedy you haven't asked for, so I'm not entirely sure it's in front of us whether you should be, in theory, someone who asked for it should have been given it. But if the remedy was in the nature of reconstruct what a timely trial would have looked like, it seems like even if it is an indisputable inference that the officer in question being referred to as Officer Rosa, I guess you kind of have to create a counterfactual world about, okay, let's say imagine the trial court had said, no, government, I'm not giving you any continuance. So now what? We don't really know what the what is. I mean, Judge Beckwith mentioned the possibility that the judge could have passed it for a while. You could have found out how long the witness was going to testify in grand jury. Maybe they would have been able to secure the witness that day. Maybe not. Maybe there are other witnesses. We don't really know for sure. And so if that was a remedy, it seems like that remedy might require factual development beyond what is currently known on the record we have in front of us. Do you agree with that or disagree with that?
I agree with that, that there may be additional factual development that is required. I will say that while initially the district made comments suggesting that perhaps the missing officer, whoever that was, might have been able to be present, there certainly was a lot. There was a lot of uncertainty about when or if that officer would be available, and when. As the discussion moved along after the case was passed, when the district returned, it didn't say, oh yeah, we know the officer can be here at this time. So it wasn't simply at the trial call, but after the case was passed. So I think, but I agree that additional factual finding would be warranted regarding that issue.
Can I ask you, you have couched your argument resting on the proposition that these 4 or 5, I think 5 identified considerations are requirements, meaning that, if I'm a trial judge and a party says to me, I want a continuance to secure the testimony of a witness who's not present right now, I'm not lawfully allowed to grant one unless all 5 of those boxes are checked. Your opponent argues that that's not how the trial court is required to consider this, or how we should be considering the trial court's ruling, and instead those are factors, and cite some cases that treat them as factors. So what do you make of the fact that there do seem to be some cases that word this in requirement terms and some cases that word this in sort of non-requirement, totality of the circumstances, do what is reasonably necessary to have a just proceeding, broad discretion of the trial court? It seems like we have these 2 different lines of authority, and each of you pick one, and I'm interested in help from each of you about what you think we should do in terms of which of those lines of authority govern what we should be ruling here.
Sure. So certainly, as Your Honor indicated, there are cases where this court has stated described it as the movement must make a fivefold showing, right? I don't think there's any way of interpreting that other than they are elements, not factors from those cases. Regarding whether if there is conflicting authority about that, typically this court's practice would be to consider the earlier decision, unless unless the other decisions, the later decisions are explicitly overruling those in some way on some basis. But typically that would be this court's practice would be to follow the earlier decisions to the extent that.
And do you have a belief about which of these lines of authority would be the earlier, if that's the
I believe that is the line of
the
authority that I am advocating, Your Honor. But I'm happy to check that when I sit down, but I believe that is correct. The second
And
error.
I'm sorry, when you treat them as requirements, does that mean the trial judge has to, not just consider each one and, or, decide that they're satisfied and check them off, every single one of them?
So if they are considered elements, the trial court would, or at least at the stage where we arrive here, this court would need to find that the trial court found each of those things. I think this is not really a close case here in terms of whether the trial court did that. In this case, I agree there might be other cases where the proffer is made and then the court makes a ruling about that. Here, both the proffer and the ruling were insufficient, but as a general proposition, if they are elements, and this is what this court's held, yes, there would need to be at least evidence sufficient to support a finding for each of them.
And is that true in your view, no matter how brief the continuance is? So, and maybe you're drawing a distinction between passing a case and continuing it, but if you're a trial judge and a party says to you, you call the case and you're about to start, and one of the parties says, "I have a witness who's on the way. Can we pass this case for an hour?" Would you say that's a continuance and those are flat requirements, and the trial court can't say, "Well, okay, that's fine. I'm just managing my calendar, and I don't really have to go through this, have a hearing and check off 5 boxes. I can just sort of exercise my discretion and say, well, it's fine to pass. It's a brief continuance, a pass, whatever you want to call it."
I am drawing a distinction between passing the case and a continuance, Your Honor. That is, while I did not, this issue wasn't briefed, and certainly I would want to look more into that. I think certainly something the same day would be unlikely to qualify as a continuance, but anything beyond that day.
So if it was 4:55 and you're a mid-trial continuance and the party said, and the judge says, "Okay, party who's presenting evidence, call your next witness," and the party says, "Well, I had one in line, but that person is unavailable. Can we, terminate proceedings today a little early and pick up tomorrow?" And the judge says, "Sure," without checking those 5 boxes. Would you say that's a continuance, or would you say it's not a continuance? Or
sorry, and apologies. I was interpreting Your Honor's initial hypothetical regarding before a trial had began. I agree there might be a different distinction once the trial has begun. I do, however, thinking about, again, this wasn't brief, but thinking about the way this court has referred to in the context of continuances, has referred even to a request to carry to the next day when trial has begun as a continuance. I think again, not having briefed this, but maybe part of the issue here is is jeopardy attaching, right? And we're sort of in a different world once jeopardy has attached, but I agree that certainly once trial has begun, and if a trial has not begun, my initial thought would be anything beyond the day would qualify as a continuance.
can I ask you whether you're aware of any case in this jurisdiction where we have reversed a trial court's order granting a continuance?
Your Honor, I am not, as indicated in the briefing. That is, I think there are other cases where there are not a grant that support that are distinguishable from the facts here that support that. That is Bernal. Obviously, the way this court ultimately characterized the the 7 days, I believe, was as time for the government to consider the late notice from the defense expert. No, I'm not, to answer Your Honor's question.
And you said that you didn't think there was any way of interpreting some of the language that is requirement sounding like must, other than that they are prerequisites to the trial court's exercise of authority to grant a continuance. It seems like another possible way, at least, to look at that would be those are the prerequisites if you want to succeed on appeal in showing that you had a right to a continuance. Rather than saying explicitly, no trial judge may ever grant a continuance unless these 5 boxes are checked. The cases that apply a requirement generally, and maybe all of them, I think the ones at least I'm aware of off the top of my head, are ones where a continuance was denied and the party who was denied a continuance is seeking review on appeal saying the judge was required to grant me a continuance. And so if you're thinking of that language in its context, one could say that those are the boxes you need to check in order to be able to prevail on appeal, that the trial court was required to grant your continuance, or at least they're minimum boxes you need to check in order to establish that the trial court may have been required to grant a continuance. What's wrong with that way of looking at that language?
So I understand that line of thought. I will just say, and I'm paraphrasing here because I don't have the exact language in front of me of the prefatory clause, but that the way this court has described that is in order to obtain a continuance based on a missing witness, the movement must make this 5-fold showing, right? And not that certainly the context in which that is arising is necessarily an appeal. That's why it's before this court. But I don't think it would be that it would be reasonable to believe that in order to obtain the showing in the first place, that requirement would be different in terms of showing the harm that would be required on appeal. It would sort of it would also invite sort of appellate fact finding, right? That is, if this court wants the trial court to make this determination in the first instance and has laid out this law under which it should do that. And so I understand that line of thinking, but I don't think it holds up under scrutiny.
Does your argument depend on our agreeing with you that these are flat requirements as prerequisites to the trial courts having any authority to grant a continuance, or do you argue in the alternative that even if these are factors, the trial court really didn't adequately consider them or gather requested information relating to them?
I agree that the trial court certainly did not. So even if this court was perceiving them as factors, the other sort of alternative argument that was included in the brief here is that even if these are factors, the other way that the trial court abused its discretion was by either whether you want to characterize it as a clearly erroneous factual finding or lacking a firm factual foundation to conclude that the missing witness was under subpoena. That is, the trial court rested its finding in part on both issues, that is, both on not dismissing for want of prosecution and on granting the continuance on the premise that the missing witness was compelled to testify elsewhere.
There are 2 other points your opponent makes that we haven't discussed yet that I'm interested in your reaction to. One of them is the argument that, leaving aside the possibility of a continuance to secure the testimony of the officer, maybe inferentially Officer Rosa, the trial court also made a comment at one point relating to your motion to dismiss for want of prosecution and the day of trial disclosure of the PPMS information, that the remedy for that would be more time, so that there was kind of another consideration the trial court had in mind for continuance. I'm interested in your response to that thought. And just to get the other one out on the table, your opponent also argues that even if the judge shouldn't have granted a continuance, that error was harmless because all that happened was that a witness came, and that's really implicitly the government's argument is that's not a form of harm that would warrant reversal of a conviction. So I'm interested in your reaction to both those points.
Sure. So to the first point, Mr. Carper certainly never requested a continuance. And so I think granting a continuance for the benefit of party over their objection would seem very odd. but Mr. Carper certainly never asked for a continuance despite the late disclosure. The second issue, I guess this is, and I agree with this court not having decided a published opinion regarding an appeal from a grant of a continuance, that there's a little bit of a lack of authority here. The prejudice as implicit in Your Honor's first question about the remedy, going back to the beginning of the argument, the prejudice that Mr. Carper puts forward here is the evidence that would not have been present on that trial date, and this is not a situation again like Bernal where the reason for the continuance was the defense. Right?
Here's, I get that line of thinking, but I guess here's my difficulty with it. If the only remedy that you requested, at least up to today, was a retrial without any limitation on what evidence could come in, the government's argument is if that's the remedy, there's no cognizable harm because all you're going to get is a trial 2 years later that there's no reason to suppose to be any different than the trial you already got, except that it'll be a lot later than the trial it's worse in terms of timeliness relative to when you think the trial should have occurred. Do you have, so if, assuming that we don't think that the possibility of a different remedy is raised here because it wasn't briefed, do you have an argument about why the denial of a continuance was prejudicial, even if, and not harmless, even if the only remedy is a retrial, whatever, 2 years after the original trial, if we're optimistic here? Or do you, is really your prejudice argument ends up, your response to harmless error ends up really being there's a different remedy that would show that there is prejudice?
Well, Your Honor, I mean, certainly in a new trial, we don't know what the evidence would be. We don't know what officers the district would call. We don't know whether Mr. Carper would pursue the same strategies. And so I think it is speculative to say that if there was a retrial, not fact finding as Your Honor had initially posited, that the evidence would come out the same way. So I think that's speculative at this point. I see that my time has expired. If I might, I'd like to turn to what happened at the trial, if the court will permit me. That is, so at trial, the trial court concluded that proving out-of-state licensure is an element, is an affirmative of the offense rather than something that the absence of which the district must prove beyond a reasonable doubt. As discussed in the briefing, this court's application of the test first articulated in Williams by the DC Circuit in Bush has been substantially undermined both by technological changes during the last 70 years and by candidly a case that the district cited in its 28K later, Vuitch.
You do say in your brief that you seem to be asking this court to overrule Bush on Bach, but it sounds like you might also be making an argument that we don't have to because of substantial changes. Is that
That's
accurate?
correct, Your Honor. That is, I don't believe this court would need to, but to the extent the court concludes otherwise, I think given the changes that have occurred, that this court should overrule Bush on Bach if it feels like it needs to change that. But I agree, Your Honor, that I don't think it needs to.
There seemed to be something at trial where people, or in the briefing maybe, that people were talking about the technology, the changes in technology just extending to the DMV area, or is it it seems like there are a lot of facts that are unknown here underlying your position. Like, is it the case that officers are able to basically find out if someone is licensed anywhere in the country?
So, Your Honor, certainly as would be necessary to decide this case, as to the District of Maryland and Virginia, this in published opinions, this court has both talked about what Wales, the system that we're talking about here, the Washington area law enforcement system is and what it contains. The DC Circuit has done the same. For example, Sutherland, which is 486 Federal 3rd, 1355, describes Wales as a database maintained by the Metropolitan Police Department that contains inter alia motor vehicle information such as driver's licenses and vehicle registrations. Information from the DMV database is uploaded to the Wales system. This court has also addressed it in several other opinions. I'm happy to provide the sites for Carter versus United States, 614 Atlantic 2nd, 542, McMillan versus United States, 527 Atlantic 2nd, 739, but all stand for the proposition that Wales contains current driver's license information for, at minimum, the Maryland, Virginia, and the district.
Why isn't the body worn camera sufficient proof that your client wasn't licensed by his own admission?
Sure. So that takes us to the argument that was made both below and in this court, Your Honor, that is under OPER, that the extrajudicial confession alone is insufficient to prove guilt beyond a reasonable doubt. And here, that was the only evidence that Mr. Carper was not licensed to drive and did not hold a driver's license from Virginia. That was the only evidence. There was simply no other evidence.
Can I ask you on this issue, is it, I mean, in the first instance, do you agree this is a question of statutory interpretation? So the question is, did the legislature make this an element or did the legislature make it an affirmative defense? And do you agree with that?
Yes.
And so you agree that if the statute said expressly, this is an affirmative defense and the burden is going to be on the defendant to prove it, that would be lawful. And so it's just a question of how do we interpret the statute? What burdens to assign to whom?
I would say that that question is not presented by this appeal. That is whether the legislature may do that consistent with due process. That's just not the question here. But
So you're not arguing that they couldn't. You're just not sure whether they can, and that's not the issue that you are teeing up. Is that right? Okay. So if we're taking it as an issue of statutory interpretation, I guess I get a little puzzled by you're describing Williams, for example, as creating a test. As opposed to a decision that's interpreting a statute and says some things about a particular statute and reaches a conclusion about it. And there are other cases that have other statutes and have said other things like, well, if it's put in an exemption, it's probably an affirmative defense. And so I'm not quite sure that I'm following your suggestion that there is a monolithic test as opposed to different cases that apply different considerations when reaching the statutory interpretation question with respect to the different statutes. And technology is one of them, but like who would naturally have the information is often one. Whether it's put in a separate provision, whether it's called an exemption, there are a lot of different factors.
I will just say that the way that this court characterized what it was doing in Bush, and this is at 235, is applying the above stated test, referring to the test from Williams. So I think the way this court has described it is as being a test. And so that is where the line of thinking comes from.
Yeah, I mean, but I guess the question is, that's a test that relates to a particular circumstance. So as opposed to like a monolithic test that it's not so clear to me either from Bush or from Williams that we were taking the view that no statute can be determined to have created an affirmative defense rather than an element unless interpreting the statute as imposing an element would create difficulties in the way of prosecution unnecessary in the interest of ordinary fairness. I mean, that seems, first of all, you would agree if the legislature explicitly says this is an affirmative defense, then we would be interpreting it that way, even without regard to whether there were difficulties or not. There might be a constitutional question not raised here, but the antecedent statutory interpretation question wouldn't turn on that test. It would be dictated by plain language.
Agreed.
Okay.
Yes. But I guess to Your Honor's question of whether that is, applying a test to a particular set of facts, the district here is relying on Bush, as the trial court did, in the way in which this court's predecessor announced its holding in Bush was again by saying it is applying the above stated test to these facts, and there is not sort of contrary authority regarding the or the district hasn't cited it anyway, if there is, regarding the means by which to determine whether something is an affirmative defense or an element of the offense. So I'm not sure where sort of in the abstract this any other sort of test of statutory interpretation for making that determination would come from.
Well, the district, relying in part on something that was in Williams, talks about other considerations like the exemption is in a different statute, separate statute from the provisions that indisputably create elements of an offense. And then there's the exemption language and the like. So they rely on some other circumstances about how to interpret this particular provision beyond the Williams-Bush line of thinking, which is, wow, it'd be really hard to impose the burden on the prosecution to negate this.
Well, I mean, both Williams, Vuich, which the district cites in his 28K letter, all of those stand for the proposition, and even Bush itself, if my recollection is correct, all assert that the placement of the exemption in the statute is not controlling, right? Certainly it can be something that can be considered, but where this court's holding in Bush necessarily rested on the test from Williams, that is what we are left with here to argue about.
Yeah, and I guess just the last question on my mind, at least, was on this issue was if the issue is initially at least one of statutory interpretation, it seems like a challenging principle to think that the upshot of that should be the legislature must have intended that this would be an element with respect to licensure in the DMV, but not otherwise. That seems like because it used to be hard everywhere, but now it's less hard there. I mean, it seems both in terms of what the legislature was thinking, that there's some chronological questions with that and some questions of how reasonable it is to attribute to the legislature that line of thinking.
My only point is to say that the court wouldn't need to go further than what it has addressed in published opinions in Wales based on the facts of this case, right? We're not talking about someone who is from Wyoming or from California. But I will say, the trial courts make sort of determinations like this all the time, obviously not on the substantive law in the first instance, but that is in the context of self-defense. As outside of that, the more relevant here, as this court held in Osborne, when there's an allegation that the movement did not receive notice of the suspension. So it's not. Might there be difficult factual circumstances at the time? Sure, but this court doesn't need to go beyond Maryland, Virginia, and the district in order to decide this case. If there are no further questions, I'll reserve the remainder of my time for both.
Thank you. You have none to reserve, but we'll give you some time.
Good morning. May it please the court, Tylen Trayer for the district. I'll jump right into the affirmative defense argument. And I'd just like to begin with something that we've heard today and in the defendant's reply brief, that this case presents a question of purely statutory interpretation. The defendant has affirmatively waived any line of constitutional attack on the statute in terms of the allocation of the burden of proof here for the out-of-state exemption. And just another point, I know we've been referring to this as the out-of-state exemption, but I also want to point out that the exemption extends beyond just the 50 states in the United States and U.S. territories. It also includes licensure from foreign countries. So when we're looking at just this particular exemption, we're looking at a question of it's really quite remarkable, I think, to place the burden on the prosecution here to prove that somebody isn't licensed, not just in any other state, but also any other country in the world. But of course, this court has already decided in Bush that this exemption is a burden on the defendant.
Well, that's where I get a little bit confused, where you say it's a question of statutory interpretation, but then we've got Bush and we're bound by Bush because Bush is a page and a half long, and I don't really see any statutory interpretation in Bush. So if it's a question of statutory interpretation, is it a question that is open for us to decide, or are we bound by a decision that doesn't actually do any statutory interpretation?
No, it's not an open question, Judge Easterly, and the depth of the analysis or the length
Well,
of
there's
the
no,
opinion.
I mean, is there any citation to the text at all? I guess it
There is
it
citation.
replicates the text,
Yes,
but there's no analysis of the text.
yes, but this court has said
So
that
can that
even,
be called statutory interpretation?
I think so, the court was squarely presented with the question of how to construe the statute and squarely held that
Sure. I'm sorry, I'm just going to press you. I mean, yes, they were asked, what does this statute mean? But they sort of sidestepped what I would consider a statutory interpretation and went over to, this test developed in a completely different context, and said, well, let's look at this test and we'll apply it here and come to our conclusion that this is an affirmative defense. That's not really statutory interpretation. It's interpretation of sort, but it's not statutory interpretation.
So three answers, Judge Easterly. The question was squarely presented, the question was squarely answered, and moreover, this court has said that the court is bound by our prior holdings, even if those holdings are not fully explicated, if the discussion is compressed, and if more could be said on both sides of the question. That's from.
Okay, I mean, if this sounds flip, but if we had a decision that said, we are asked to interpret the statute, here's the text, the panel flipped a coin, we decided that it means what the prosecution thinks, so that's what it means, that's our decision, and that were written down in a decision, would we be bound by that as a matter of statutory interpretation?
Well, in that situation, I think there might be much more of a question as to whether the court was actually interpreting the statute as opposed to relying on the coin toss in that particular situation. But yes, a prior decision of this court is binding, has precedential force. And moreover, this is a decision of statutory stare decisis that is entitled to, as this court has said, enhanced force. And that makes good sense because if there is ever an interpretive mistake, it's very easy for the legislature to correct that interpretive mistake as compared to a decision construing the Constitution, where it's much more difficult, if not impossible, to go back and correct such a mistake. And the legislature here has not hesitated over the years, time and time again, to amend this statute. And most recently in 2021, the council amended the statute, inserted provision J1, which makes it in all circumstances in which an individual needs to rely on a license, makes it possible for them to rely on an electronic version of the license. And I say this only because the committee reports that amendment notes that the council was taking into consideration developments in technology and the proliferation of cell phones. So I think there's an example of where, the development of technology and the use of a license by the defendant in these situations was clearly on the council's mind, but the council did nothing to disturb this longstanding provision, and knowing that this court's decision in Bush has been on the books for 70 years. And I think my friend on the other side's position is really quite remarkable, that essentially the passage of time or technological developments could change the interpretation of a particular statutory term. He doesn't cite any case law for that proposition. And again, I think it is a remarkable one. That's simply not how statutory interpretation works. I'd also like to offer one point of clarification to something that we said in our brief. The Wales system does allow MPD in the field to access driving license records throughout the country. It still doesn't solve the problem of accessing licensing records from other countries throughout the world. There's also a big difference between being able to access those records in the field as compared to proving beyond a reasonable doubt at trial that somebody does not have licensure. Even in the United States, I think the logical conclusion of my friend's position would be that the district would need to not only search the records of every DMV throughout the country, but also bring in a witness from all of those DMVs due to confrontation clause considerations in order to testify as to those records. So there are a lot of good reasons as to why this would be unworkable. But luckily, as we've discussed, this court has decided the issue definitively in Bush. And I guess I'll also point out that if this court were to view itself as being in a position of overruling a prior decision of this court, even sitting as a panel and not as this court sitting en banc, that would also make the district an outlier in terms of other states across the country. We looked at a number of states. We didn't quite get to all 50, but as far as we can tell, the vast majority, 40 or so states at least, have statutes that are written pretty much identically to the districts. And there are fewer cases on this, but there's cases from Ohio, Texas, Maryland. There's a case, Smith v. State, 425 Maryland, 292. Just in 2012, the Maryland court looked at this Maryland statute that again was written substantially the same as the districts and held similar to this court in Bush, that the out-of-state exemption there, that is not a burden that's on the prosecution to prove. So I'm happy to answer any further questions on that issue. Also happy to move to the continuance question. I have 4 points I'd like to make in response to my friend on the other side. First of all, as we heard today, and the district is also unaware of any case that has found an abuse of discretion from the Superior Court granting a continuance. And I think there's good reason for that because, as the panel here noted, the delay in this case was 12 days. I think it's often the case that with these types of minimal delays, there will be very little, if any, prejudice to the defendant. And I think it is a logical conclusion of the remedy that's been requested here in Judge McLeese. I think you're exactly right that the defendant has never requested a retrial with contemplating that the district wouldn't be able to provide for the testimony of Officer Rosa here, but has simply asked for a retrial now years later. And I think that only goes to show the lack of prejudice here.
But do you agree that there would be prejudice if, in fact, the judge had viewed these factors as requirements, had gone through them, and they weren't all met? And what would have happened is, the trial would have had to go on that day without the witness. Isn't that a situation that creates prejudice?
I'm not aware of any case saying that just the district's pointing to the district's ability to put on its case in chief, that would constitute prejudice. And to go back to point raised by Judge McLeese, I also read those cases, Judge McLeese, as standing for the proposition that the mandatory language in those cases goes to a showing on appeal as to what somebody must show to be legally entitled to the continuance. And again, importantly, those are cases where the continuance has been denied, but not prerequisites before a court is even allowed to exercise any discretion whatsoever. I think that would run contrary to what this court has said about granting wide latitude to Superior Court judges, about
maybe so. I mean, but we talk about discretion and we say in numerous instances that discretion is bounded. These are the things that we want courts to consider. And in certain instances, they have to tick through certain considerations. And it sounds like the government's position about continuances and the cost to the defense of having a case hang over their head is sort of cavalier, right? Like, the defense shows up, they're ready to go, they've got their evidence, they've got their witnesses, and then the government, can ask for a continuance in the court, can grant it in its unbounded discretion, and it doesn't prejudice the defense at all. I mean, I'm not sure that that's an accurate sort of assessment in a real world sense of what the prejudice is. But I guess my factual question is it clear that the officer was truly unavailable? I mean, part of the problem seems to be that the court didn't do an adequate inquiry, but that the officer, whoever it was sort of around. And I'm looking on page 26 of the transcript, where the prosecutor talks about, it says something, I believe he's going to walk over to the courthouse now. I don't know how long we'll have him for, but I guess he's not currently before the grand jury. And then they pass the case and they talk about maybe talking to the officer in the hallway. And so, I mean, he seems to be around and or she possibly available for some period of time. Unclear how much time the government needed to have the officer on the stand. I mean, there seem to be some factual questions. Is that fair?
So several answers, Your Honor. Yes, and I think we heard from my friend on the other side that if there were to be a remand here, that this would require further factual development, which I think would be an extraordinary expenditure of resources where we don't think that there's actually any prejudice. But I'd like to return to the first part of your question. We are in no way suggesting that a trial court judge has unbounded discretion. This court acts as a check on that discretion. And of course, there's always, speedy trial guarantees as well. But here where there was a 12-day, that sort of minimal delay that also worked to the benefit of the defendant in these particular circumstances, first of all, I think it is very clear from the record the basis on which the Superior Court is granting the continuance. Moreover, I do dispute the characterization that we weren't able to proffer.
Can I stop you there and say you
Yes.
think it's clear the basis? I mean, because the court says, and now I'm on page 23, after the government says, well, the witness is not unavailable and we're not exactly sure, is it grand jury, is it a trial? And the court says, I need a little bit more concrete understanding of why we don't have the witness. And what I'm hearing is the witness may be there, but you're not, and it's sort of garbled. But the court says, it sounds like you aren't 100% sure on the reasons why the witness is not available. And the district says, that's right. He may be in front of a grand jury or it may be a trial. And then the court says, okay, you're just not sure which. And then the court says, okay, now I'm going to deny it. I mean, it's just sort of, it seems like for a moment, the court is trying to get more information and then it doesn't get more information. And then it says, I'm going to deny the motion to dismiss for want of prosecution. Sorry, didn't read all the way through, but the court is sort of saying, sure, have your continuance. I don't have any more information. You haven't given me any more information. My additional probing took me nowhere, but never mind. Go ahead, government. You can have what you want. Leaves something to be desired. Don't you agree?
So I read the transcript a little differently. I read the transcript, the officer here.
Well, I just read from the transcript. I mean, that's page 23 of the transcript.
Right, and so I think that there was some factual confusion about whether or not the officer had been called before a grand jury. And the prosecutor said, I've talked to my officer. He said he's been called before a trial. Of course, he's not an attorney himself. We checked and apparently there were no trials scheduled for that day. And then in reconnecting, realized that he was called before a grand jury. And I think the Superior Court.
Well, I just read where they told the judge they didn't know, and then the judge ruled.
Yes, and I'm sorry.
Right. So that's page 23.
Yes, and I think around that same point, the Superior Court says, so trial or grand jury, but the main point being that the officer has been called before another tribunal. And so I think right before denies the motion to dismiss for lack of prosecution, says no, the officer's been called before another tribunal. I don't think there was any serious question here that the district was not being truthful in its proffer about whether or not the officer was called before another tribunal. And moreover, from the transcript, we do know.
It's a question of truth. It's just clearly the witness, who, as you know, is not a lawyer, doesn't quite understand where they are expected to be. So the basis of the government's representations may be subject to question because the person that they're talking to doesn't quite understand where they're going.
Yes, and ultimately the Superior Court was satisfied with the answer that the officer was called before another tribunal. And the transcript does reveal.
Right, and we're trying to figure out if the court should have been satisfied because they didn't get very much information.
Right. And to my opposing counsel's argument here about just exactly what was proffered, we know on pages, I think 3 and 8 and 9 of that transcript that that the testifying witness was an officer, had been called before another tribunal, that the district had only learned that information that morning. And I'd also just
when you say the district, just to interrupt on that aspect of it, one of the requests that was made in the trial court was to focus on when the officer knew of the conflict. who is also a district employee. So you're kind of conflating the attorney for the district and the district, which might be a broader concept. And the trial court declined that to look into that, which would be relevant to diligence. It seems at least arguably by saying I've ruled, I'm not going to do that. And in fact, the defense attorney said, I have two requests. Here's one of them. And the trial court says I've ruled. So we don't even know what the second request would have been because the trial court wasn't of a mind to hear it. So even if diligence is just a factor, do you think it was adequately explored by the trial court and explained as it might bear on the exercise of discretion if these are only factors?
Yes, and thank you for the clarification. To be precise, yes, as the prosecutor proffered to the Superior Court that it had only learned that morning that the officer had been called before another tribunal. And so that information was before the court immediately as soon as the case opened. And so there may, from the Superior Court's view, I'm not sure why there would have been more to inquire into at that point, and the Superior Court was.
What's wrong with defense attorney's implicit point that if diligence is a factor to be taken into account here, you should be considering not just the diligence of the prosecutor who may be surprised by this development, but by the diligence of the officer who also works for the district, who may well have had this information available for a while and is now springing on everybody belatedly, and now everybody's here for a trial, and now we're not going to have it because the officer didn't respond appropriately to information the officer had as a part of the prosecution team. What's wrong
That's
with
right.
that? Is it at least a relevant consideration?
No, and it's certainly a relevant consideration, certainly a permissible consideration, but the Superior Court also is in a position and is given wide latitude, and certainly in the press of, the pressing demands in trial court to accord more weight to the prosecutor's proffer that it had only found out that morning. And then also.
But it seems like, again, here, like, there's inadequate information. I mean, why did the prosecutor only find out this morning? I mean, what, did the prosecutor talk to the witness the week before and say, hey, we've got trial, and you're ready? I mean, it seems like an area that might have been worth exploring for the trial court to ask the prosecutor, how is it that you only found out this morning? Did you speak to your witness yesterday? Right? That would seem to be a normal thing to do if you're putting someone on the stand, to at least have a conversation with them the day before. And if the officer, didn't tell them the day before, or did tell them the day before, that would be pertinent information. But we don't know any of that because the court didn't probe.
I think it's very difficult to second guess sitting here after the fact. What are the most relevant or overriding factors that the Superior Court should have considered? And I think that's why this court has said in very strong terms that when it comes to a motion to grant a continuance, or that the grant or denial of a continuance will be rarely overturned. We don't have in the record information as to why the prosecutor only found out that morning from the officer. But again, there hasn't been any serious contention that was.
I mean, making arguments like this makes me sort of think, gosh, we really should be more directive to trial courts about what they must do, instead of leaving it to their discretion. Because if we leave it to their discretion and just say, well, they don't have to ask any questions, and then they can make discretionary decisions, that doesn't inspire confidence.
So several answers, Judge Easterly. I think that would really be interfering with this court has said time and again is the wide latitude given to Superior Court.
But we've
judges.
also said time and again, they must consider these factors. So it seems like it would align with that pretty well.
Well, again, I don't read those to be mandatory factors, and I do read them, as Judge McLeese's, at least his question earlier, indicated as minimum showings, again, in the situation where a continuance has been denied. But to take a step back here too, I think the Superior Court's reasoning is quite clear, and here the continuance that was granted did work to the benefit of the defendant also, and giving
He didn't
more
want a
time.
continuance. I don't understand that argument.
Well, the fact
He
that the
didn't ask for
Superior
a
Court-
continuance. He asked for the case to be dismissed.
That's right. And so the Superior Court did give a lesser remedy to cure the asserted harm.
It's
which
not a
was that
lesser
the-
remedy. It's a remedy that he opposed.
But in terms of the asserted harm from not receiving the PPMS materials earlier in time because the court's protective order hadn't issued
And
until the
is there
night before.
any, I didn't see the actual PPMS materials in the record. So I don't know how copious they were. And I don't think the record indicates that. It is true that the defense attorney indicated that they had been received belatedly, and the defense attorney felt aggrieved by that. And the trial court does say, well, you might need some additional time, but depending on what you think a continuance is there anything in the record that would support the idea that there would have been any reasonable need to have 12 days or anything, even an entire day of additional time for the defense attorney to prepare to review the PPMS material and respond accordingly?
I mean, the only thing we have in the record is we know at trial that the PPMS materials were not actually used, even though we don't have the PPMS materials. So I think to some extent that goes to, this question of how much time would have been needed to actually review the materials. And then there's been no contention that 12 days here was insufficient, but at bottom here.
I mean,
So my point was my point was the reverse, which is I mean, I get your line of thinking, which is when the trial court was talking about these related set of questions, the trial court does refer to the idea that with respect to the disclosure, the day of trial disclosure of the PPMS materials, that additional time might remedy that rather than dismissal. So I get that line of thought, but I don't quite see the connection between that and a 12-day continuance, because the defense attorney wasn't asking for a continuance relating to the PPMS materials. And I don't see that the record necessarily provides any particular support for the idea that a review of those materials would reasonably have required any continuance, much less if you think of a continuance as more than, a day or more, which one could debate. So that's why I'm not quite sure that that comment by the trial court can bear the weight of kind of an independent justification for a 12-day continuance, which wasn't, the trial court was originally trying, I think, for an 8-day continuance, and then 4 of the days were related to scheduling. But so that's the difficulty. That my question was not, I don't think there's any suggestion that 12 days wasn't enough. The question is whether the disclosure of that provided any justification for a continuance as opposed to some time.
Right. And I think the Superior Court here was weighing a number of factors, including, as we said, the factors that were proffered by the district here going to the.
I'm sorry to interrupt. I apologize. But what's the evidence on the record that the trial court was weighing diligence? I mean, it would be one thing, your case would be better if the trial court had said, look, I understand the point you're making, defense counsel. You're saying that the prosecutor may have been diligent, but maybe the officer wasn't. And we could go and try to explore that. But I'm going to assume that, maybe the officer knew and probably should have let the officer knew and probably should have let the prosecutor know. So I'm going to, weigh diligence. I'm going to assume that diligence probably doesn't work very well for the government, but nonetheless, it's only a 12-day continuance. You're not prejudiced. There's also this PPMS material. So if the trial court had actually expressly considered some of these factors, your case would be better. But I just don't actually see any indication that the trial court, the trial court originally showed some interest in learning more and then ultimately doesn't learn much more other than it's definite that the witness has been called to testify in front of a grand jury. That's kind of the only thing that gets nailed down. And then the trial court's kind of like, well, I don't really, doesn't seem to have much interest in anything that would be relevant to the rest of the factors and doesn't explain any balancing and just says, I've ruled. So even if these are discretionary factors, I wonder whether the record supports affirmance rather than remand or something.
Yes, so several responses, please. First of all, this court has excused the absence of express trial court findings where required by statutes, where the record is so plainly supports the conclusion that the required findings were made. That's Jordan v. Jordan, 14A 3rd 1136. I think the question also presumes that these considerations are all mandatory, and I think that would really be promoting empty formalism.
Jordan v. Jordan is the family law case.
That's right.
And in that case, the court made detailed factual findings, and then in assessing the best interests of the child, if recollection serves me, just doesn't go through the factual findings that it had already made. It seems a world away from what we're looking at on this transcript that is, several pages long in relevant part, where the court doesn't make any factual findings, doesn't really ask any questions, doesn't do any balancing, as Judge McLeese has noted. I don't think Jordan v. Jordan helps you very much here.
Well, so Judge Easterly, the issue
And I
there
think we have a lot of cases saying that where we accord trial judges discretion and we give them factors or requirements to consider, that they really have to consider those in order for us to determine that they have properly exercised their discretion.
So several responses, Judge Easterly. Just on the Jordan v. Jordan point, the issue in that case is whether or not the Superior Court had made required factual findings as to whether the father would pose a danger in being awarded joint custody of the children, or would otherwise, whether the joint custody would significantly impair the children's emotional development. And so there was a question there of potentially missing factual findings explicitly made on the record there. And that is the conclusion that this court came to. But I also think it's important to consider here the effect this would have on the defense as well. I mean, if this court is really going to say that all of these factors are mandatory, and to Judge McLeese's point earlier, I don't see a principled distinction between passing a case and a continuance that lasts for 24 hours or more. If we're going to say that in every case where the moving party requests a continuance, that they need to check the box in order to walk through these requirements, the Superior Court in every instance, even when it's passing the case, because maybe the attorney or the witness is in the restroom, at that time, I think that would really be remarkable. And the abuse of discretion test also, at the end of the day, when we're looking at whether there's a factual foundation or support in the record, I mean, at bottom, this court wants to be able to review, again, for an abuse of discretion, the reasoning of the trial court. And so there might be some instances where we have absolutely no indication what the trial court was thinking. And that's far from the case here. This court may disagree with the Superior Court's weighing of these factors.
I
but
feel like I don't have any idea what the trial court was thinking about the relevance of diligence.
I'm sorry.
I'm sorry. I feel like I don't have any idea what the trial court was thinking about how to weigh diligence against other variables.
Well, I think it's
Well,
implicit in placing more weight on the availability of the witness down the line, the identity of the witness, the fact
Well,
that
we don't, on the identity of the witness, that was not, that's inferential, I
It
guess
is.
now. I don't know how, there's nothing that, what the trial court doesn't say explicitly again. Well, I am inferring that this is an essential government witness. There's no indication, there's no explicit indication of who the witness is by name, or also how important the witness's testimony was. All of that is maybe kind of assumed or inferred or implied, but there's nothing express about any of that unless I'm missing something.
That's right, Judge McLeese. But to take a step back here too, this is a no permit case. This is not a complex days-long trial with scores of witnesses. I think everybody was on the same page here about, yes, I totally agree that it was a matter of inference, that the district did proffer that its witness was an officer, but did not specify the identity of the officer and was instructed by the Superior Court.
Or what the officer's testimony would be, or whether the officer was an essential witness. None of that is expressly said.
That none of it is expressly said, but again, Judge McLeese, this is a no permit case with 2 witnesses put on by the district, no witnesses.
Well, that we learned in hindsight. I mean, it's not like the government said that ahead of time. That's also that's all hindsight.
That's correct. But I think that, and also we're sort of looking at this after the fact. I think, in the Superior Court, in the press of the trial court, I do think that everybody was on the same page here about, and the Superior Court could permissibly infer, knowing that this was an officer in this no permit case in a trial that was not scheduled to take longer than a day, what that officer would testify to.
And I just think we should infer that the trial court inferred that.
I'm sorry.
You think we should infer that the trial court inferred that? Because the trial court doesn't say that. So again, you think we should infer the trial court inferred it?
And Judge McLeese, it could be the case that there could have been a better articulation, on this record. I would suggest again that in the press of the trial courts, where I think there was very little question in these particular circumstances, and we are looking at the circumstances presented in this case. And at the end of the day, I just want to go back to the point also about remedy here, that if the remedy that my friend on the other side has requested is really a retrial years down the line, I think that precisely answers the question of whether there was any prejudice that occurred here as a result of a 12-day continuance. And if—
What about his argument that would essentially create a right without a remedy?
I don't think it's a right without a remedy. I think he also, in his colloquy with Judge McLeese, recognized that there's lots of ways to address these issues. And one way is just to pass the case, right, in the moment. And so there's lots of tools available to the Superior Court. And the Superior Court judge in the first instance is best placed to consider everything that's happening before the court in order to make the best decision, exercising its discretion in that moment. Thank you.
Thank you very much. Mr. Madsen, we'll give you a couple minutes.
Thank you, Your Honor. First to the question that came up earlier in the argument regarding at least the way you characterized the Judge McLeese as different lines of authority regarding whether these are factors or elements. The earliest case that I see cited in the what was ultimately the district's brief is O'Connor from 1979, which refers to in fact, it supports the proposition that they are elements, referring to these as a minimum requirement. And I will say to the question of whether that's discussing the showing required in the trial court or the showing necessary to obtain reversal on appeal. The language both from O'Connor, from Bedney is talking about the showing that must be made in the trial court. Not, it doesn't say, okay, we're addressing harm here and here's how we're going to analyze it. And so I would stick by the position in the briefs, which is again that these are elements, not factors. The government also referenced the idea that this court wouldn't consider technological developments in terms of the law. Certainly, this court has considered those in the Fourth Amendment context. I'll also note that while this court has not ultimately changed the standard of review, because obviously that would be a much bigger decision. Certainly, this court has considered in a few published opinions. Ward Minor, I believe Henderson, has considered the impact of technology, even on things as broad as the standard of review. Here we're talking about a very particular offense in a case of statutory interpretation. So I don't think the notion that this court would not construe statutes differently based on technological developments holds up. The government also sort of later in its argument referenced the idea that this would be unworkable and that this showing would need to be made, even to pass the case. For one, as a practical matter, in terms of the trial was not going to begin at 9:30, on this day anyway. The court has a morning calendar. It was going to come back. So even without sort of any grant of whether we're going to call that a continuance or whether we're going to call that a pass, that's not when the trial was going to begin anyway. Certainly there were questions about readiness at that time. In my very brief 15 seconds left here, I'll just add that the district sort of continues to, and I think I agree with the characterization, ask the court to infer what the trial court inferred. That's not what is before the court, and the court should reject its efforts to fill in the gaps with what it would like the record to be. And for all those reasons, I'd ask that Mr. Carper's conviction be reversed. Thank you.
Thank you, Mr. Madsen and Ms. Trayer for your briefing and your arguments today. We'll take the case under advisement and we are adjourned.